its 4th edition, we are very proud to see it becoming the leading forum on investor-state arbitration in the region. I will keep my remarks very brief, given that we're a little bit late, and especially as we come right after Thanksgiving, I will focus on expressing gratitude to FIU Law for hosting us, and in particular, Dean Gomez and Michelle Artieda, whose support has been essential to making this conference a success. To Inés Calderón, MIA's Executive Director. After nearly a year as chair, I can say with confidence that MIA's would not be here and what it is today without her vision, dedication, and steady guidance to catch a mass for creative work behind the scenes, to Silvia Marzilli, chair of this conference, and Francisco Rodriguez, chair of the Miami Arbitration Week Steering Committee, for their tireless efforts. To all of our speakers, with special thanks to Doug Bishop, our keynote speaker today, for generously sharing their insights and experience with us. And finally, to all of you, your presence and participation are what make this conference and MIA's itself a true success. It is an honor to have you here today. And now it is my privilege to announce the winners of the 2025 MIA's Writing Competition. This year, the prize committee, Richard Lorenzo, Aba Borrasso, Al Lindsay, and Dean Gomez, reviewed 12 eligible submissions through a blind process. None of us knew the authors' identities until after the decisions were finalized. And after thoughtful consideration and deliberation, the committee unanimously awarded 2 co-first prizes to the following work. The Earth, Wind, and the Rule of Law, Harnessing International Arbitration as a Viewpoint-Neutral Forum for a Carbon-Neutral World by Martina Chun. Critical Mineral Dependence in Investment Arbitration and the Essential Security Doctrine by Nicolás Celi Bustacara. And in addition, the committee awarded an honorable mention to Arbitration on Trial, the Indian Supreme Court's use of public policy as a double-edged sword in setting aside proceedings by Shreya Singh. Congratulations to all 3 authors, and we invite now each of you to share just a few brief remarks.
Hi, everyone. Hello. First, I wanted to say heartfelt thank you to Miami International Arbitration Society for having me here today. It's my first time in Miami, and I am very honored. Arbitration has always been a dream of mine. I studied at Pepperdine and started my career in international arbitration in Korea. So I'm not gonna lie, I'm very happy to be back in America, in Trader Joe's. But back to my paper. Climate change is a defining issue facing all of us. It has no borders, and addressing it requires coordinated global action. In my paper, I argue that international arbitration is essential in helping us transition to a carbon neutral world. I argue that international arbitration is essential in helping us transition to a carbon neutral world. My central thesis is simple. A sustainable world requires a sustainable rule of law. By sustainable rule of law, I mean a system that is viewpoint neutral, a framework that enforces rights and obligations impartially, regardless of the stakeholder, their position, and their interests. Without such neutrality, global efforts to confront climate change simply cannot succeed. In practice, tribunals have consistently upheld states' rights to regulate non-discriminatorily, as in Methanex in 1999 and in Glemis in 2009. The problem arises when regulation is inconsistent or unreasonable, granting permits and then revoking them due to political backlash, leaving investors in a limbo. A similar dynamic occurred in Burlington versus Ecuador, where the tribunal both protected investors' legitimate expectations and at the same time held investors liable for their violation of environmental obligations. Cases like this show that arbitration can balance investor protection and state regulatory authority. A key challenge for the environment, in my opinion, is infrastructure. Innovative technologies, whether it's for clean water, carbon capture, or phasing out fossil fuels, must be distributed globally. This requires cross-border investment and proper legal protections to ensure a free flow of innovation. Arbitration, alongside domestic regulations, provides a balanced framework. To conclude, international arbitration is an essential pillar of global justice. If it risks deterring climate policy, the solution is perhaps not to dismantle it, but to refine it so that it strikes the proper balance. If the 20th century built arbitration to tame international commerce, perhaps the 21st can use it to safeguard the planet. Thank you.
Good morning, everyone. First, I want to say thanks to the Miami International Arbitration Society, Professor Gomez, and all of the organizing members of this competition. Let me start with a simple thought experiment. Imagine you have a strategic rival, perhaps even an adversary. To defend yourself, you build advanced weapons. But the key materials needed to produce those weapons can only be obtained from that very rival. That is the reality of today's dependence on critical minerals and the starting point of my article. As I said, good morning. My name is Nicolas Celibus-Sakara. I am an international arbitration attorney and a PhD candidate in international economic law at the University of Ottawa. My article examines a challenge that international investment law has not yet fully confronted. States are increasingly exposed to structural vulnerabilities in critical mineral supply chains. Yet, essential security clauses, the treaty-based national security defenses, were not designed for these long-term geoeconomic risks. Critical minerals, like gallium for high-frequency semiconductors or rare earth elements for the magnets in missiles and drones, make modern defense systems possible. But here is the core problem. China controls up to 90%, of the processing and refining of these minerals, meaning the world's major military powers, like the US, depend on their strategic rival for the materials needed to build the weapons that defend them from that rival. This is not just a trade issue. This is a structural security vulnerability. And when states adopt measures to reduce these vulnerabilities, like investment screening requiring divestiture, they risk investment treaty claims because essential security clauses in most treaties were written for a different era. And this is demonstrated by case law. For example, in the Argentina cases, tribunals interpreted essential security clauses with a total collapse standard. While in SEDA versus Colombia, the approach shifted to a highly differential plausibility test. These two extremes highlight the doctrinal gap The geoeconomic realities of structural vulnerabilities don't fit neatly into either of those positions. In other words, the geoeconomic order has changed, but our doctrines have not. My article proposes a way to bridge that gap by giving tribunals objective indicators to distinguish legitimate security measures from disguised industrial policy. In short, a structural dependence on critical minerals is one of the defining security challenges of our century. If essential security clauses are to remain credible and relevant, they must adapt to this new geoeconomic order. Thank you very much.
Good morning, everyone. Thank you so much for having me, to Mias for organizing this, and special thanks to Dean Gomez. I met him in Chicago in one of these nerdy conferences, and I was telling him how much I love arbitration, and he urged me to participate in this competition, so I'm very happy to be here because I'm literally here because of him. My paper is on empirically studying how public policy is used as a ground by courts to set aside and enforce arbitral awards. And currently, my research is limited to India, but I'm hoping to expand and compare it with more pro-arbitration jurisdictions like the UK or Singapore in basically the Asian region. The reason I chose this topic was because when I started reading about arbitration, everything was really doctrinal. Everyone was writing about why things should be a certain way, why public policy should mean a certain way. But I always wondered how it's actually applied. I was at Stanford for my master's, and everyone asked me, but where's the problem? Like, why are we answering these questions? And my professors there, my thesis advisor, Professor Hensler, urged me to look into the data. And I opened my Excel sheet, and I started reading cases from India, and started seeing how many cases are actually being set aside on public policy grounds. What are the sub-grounds that are being used? What are the reasons? And which kind of cases are being set aside on public policy? Again, Professor Hensler, because she has had such an integral role in this thesis, she often says that arbitration is not just a private mechanism, which is something that we often say. It's actually a mix of public and private, because eventually a lot of these go to the courts, and then the courts decide how it should be set aside or enforced. And so this paper is just a starting point into empirically delving into the world of arbitration and just understanding this grayness of what public policy is. Just my last 2 lines on what's happening in India. We had an amendment in 2015 which hoped to make arbitration a little more prominent in India, and optimistically, it looks optimistic, and my research showed that things are not that bad, that courts have actually reduced interfering in India after that amendment. But I'm very happy to talk about this topic or anything arbitration during the coffee break or later. Thank you so much for having me. Thank you.
All right, thank you to the 3 of you for coming all the way here to Miami. I need to remind you, we have an app, and you will be able to participate with the app in our next sessions, so please download it. You have the QR code in the program too. And again, thank you very much for being here, and I'll hand it over now to Silvia Marzilli, who is the chair of this conference.
Welcome to Miami. I'll keep it very short because if you know me, I'm all about talking about the substance and not, expanding on the welcome remarks. But I do want to say a few words about this program and the effort, the concerted effort that we always put into it to make sure that this is a highly intellectually stimulating conference. And for that reason, we expect a lot of our speakers and moderators, so no pressure to all of you here. But the idea of having debates is precisely to show you what our colleagues who specialize in this area actually think about the issues, how to argue them, and so on. And therefore, that explains the format. Without further ado, I'm going to pass the floor to Manuel, who's the Associate Dean and host here today, and thank you all so much for being here. Thank you.
So unlike Sylvia, I'm all about the welcoming remarks and nothing of substance. Those who know me know that that's my role. Just kidding. Well, I'm delighted to welcome you to FIU. It's a way how the university gives back to MIAS, which in turn has given back to the university and has given to FIU for a long time. About the time when that picture was taken, 2008, 2009, Diego Gossis approached it. Diego Gossis was not, I don't see Diego here, approached me to ask whether we could do something at the university on investor-state arbitration. In parallel, Richard Lorenzo had approached me to propose that we do a Latin American focused conference dealing with states in arbitration. It was investor and commercial state. So two parallel ideas came to fruition. The first one with Diego, because anybody who knows Diego Gossis knows that he's not a mainstream person, became an event that has been known as the hangover. That's right after the ICC conference, and there will be the 15th hangover on Wednesday, because nobody wanted to talk about investor-state arbitration in the context of the ICC conference. Christian Leithley, who's somewhere around here, was one of the first speakers we invited to FIU on this event, not this event, so the hangover we did at FIU right after the ICC conference, and it was to talk about investor-state arbitration. The Hogan Lovells proposal of doing a conference that focused on Latin America came to fruition in 2009, and we hosted it for about 2 years or so, and then it was overwhelming because there was a lot of stuff going on arbitration related, and was a spring conference. And those were predecessors of a lot of positive things that have happened in this community. MIAS grew. The interest for coming to Miami and seeing Miami as a serious place for arbitration grew exponentially. The ICC has reaped the benefits of that evolution. The ICC has been a wonderful organization that has been the catalyst of a lot of things that have been going on in Miami. There is a Miami Arbitration Week among the 50 arbitration weeks that happened around the world, but the truth is that arbitration in Miami doesn't need a week because it happens all the time. So I'm just going to conclude by saying that it's a pleasure for FIU to see that. Then MIAS took the step a few years ago. This is the fourth formal investor-state conference when the reality brought to this community the sense that there is enough material not to do just another conference, but a different type of conference, a better type of conference. So we think this is a better type of conference because there is intellectual engagement. You see that the organization MIAS is intertwined with its community. It's intertwined with academic institutions, and that's not necessarily common in all the arbitration weeks that you see around the world. I am delighted to see that MIAS supports educational endeavors. The writing competition was Silvio Marchilli's idea a couple of years ago, and it took off incredibly. The articles that were selected, that you heard brief presentations, will be published by FIU's World Arbitration and Mediation Review. So welcome everyone. It's a pleasure to do this, and we hope it's a productive conference, and we're sure it's going to be great. So I'm supposed to announce that there is the next panel starts right away. Is there a break? No break. So then I think and I have to get my stuff.
hear me? Yep, I think so. I actually want to pick up on something that Professor Gomez started talking about a little bit, because I think it's been enough years now that it would be nice to get a little history about MIAS and how it came about. And it started with a gentleman called Bert Landy. Bert Landy had been my partner at Steele, Hector, and Davis, and a great corporate partner in international. He really coined the idea of international in Miami before any of us really knew what we were doing. I had started doing some arbitration back at Steele, Hector back in those days. And Bert called me and said, by then he had moved to Ackerman, and said, listen, I got this crazy idea. Do you think that a bunch of law firms in Miami who compete feverishly against each other could put down their differences and come together as a group with one mission and one mission only, which was to make Miami really a center of arbitration, of international arbitration? And I, of course, being the litigator, said, you're crazy, Bert. What a horrible idea. But being it was Bert, and any of you in the room that knew Bert, Bert didn't take no for an answer. Bert just kept plowing ahead. And so next thing I knew, I was on a board of MIAS because Bert said that we really had to do this. And we did. We started putting our differences down, and we came together as colleagues to really create what you heard Professor Gomez say it is today. We're very proud of the fact. I think most now statistics say that in the U.S., we're more or less always the second most picked venue for international arbitration, in addition to all the other things that we've talked about, the events that we do. We'll never surpass New York, of course. There's just a lot of reasons for that in terms of financial documents and whatnot. But Miami really now today is cemented in the notion of being an international arbitration center. And I think that in no small part is due to the vision of this one gentleman, Bert Landy. So I just wanted to take a moment for all of you who may not have known him to know a little bit more about him. But here we are, 20 plus years later, and we are proud, and I'm proud to welcome you all to, again, Miami Arbitration Week that MIAS hosts, and that we will begin today, and we will continue through Thursday of next week. In fact, there's an event at Hogan Lovells at my offices on Thursday night, and you're all invited to attend that event as well. So now, for this first session, first of all, good morning, everyone, and thank you for being here so early on a Sunday morning, and we really do appreciate that. You see to my right, I have a very small panel, but a very powerful panel. It's a panel that combined, the two of them have over 50 years of experience in terms of international arbitration, investment treaty disputes, investor states, and they have a lot to say, and hopefully a lot to debate amongst them. As you heard, there's the app, and so we're going to go both low-tech and high-tech today. So we'll have some low-tech things, and we'll have some high-tech, but as you'll see as we go along. But I do welcome you to sort of use the app, and that I can then sort of maybe see the questions on here if you haven't. So, but also feel free, again, low-tech, raise your hands, ask questions, make comments, debate the debaters in terms of what we're saying and what we may tell you. But anyway, so Sara Marzal, Sara has been with ICSID for over 10 years. She serves as case manager and primarily handles all the Spanish-speaking state cases. She has also been involved in a number of the key committees at ICSID, including environmental and climate change laws. A lot of the issues that we're going to talk about today that's impacting investor state cases will deal with a lot of these other socio-political issues that we'll see have the interplay between what we see in investment treaty disputes and what we see in the real world. Before that, she had a long history of working with some of the very top law firms in international arbitration. So again, like I said, many years of experience to share with us today. What can I say about Manuel Gomez? I mean, he's an institution. We're here in his institution, thanks to him. But I've had the pleasure of working with Manuel for now almost 20 years as well. He reminded me that I'm always asking for the clickers every time we do a presentation. We almost didn't get one today, but we do have one, so we're good to go. But again, in addition to being a fantastic professor and teacher to many students who just applaud all the work he's done in international arbitration, He also serves as an international arbitrator himself and also legal experts in the areas of international arbitration and Latin American jurisdictions. So again, I think we're going to have a great panel today in terms of the discussion that we want to present to you all. So I'm going to start actually with not presenting a question to them, but presenting a question to you all. And I don't know if yeah, here we go. And the question to you all, and this will be part of the low key, so this is just going to be by a show of hands, is do you think, and this is the fundamental question when we're talking about ISDS, is do you really think that it has fulfilled its purpose of helping Latin American countries attract foreign investment? Is it truly a tool to do that or not? Show of hands, yes, if you think that it's served that function. Okay, so, and we'll go back to that in a different kind of question later, but I assume the rest of the hands that didn't go up are either still not have had enough coffee or believe the answer is no, it really hasn't served that purpose. So we're going to explore that question in a lot of different ways with various different questions I'm going to ask my panel. But I will start with Sara, and I will ask the fundamental question for someone that's coming from ICSID is, has it attracted more foreign investment or has it been a subject of abuse in terms of countries and the moving forward of countries in terms of different issues that are faced in Latin America?
Thank you very much, Dan, for the introduction, and it's a pleasure and an honor to be here today. So to help set the stage for this question, I think that it's very important to look at the historical context, how ICSID was created, and at the data that results from almost, six decades, sorry. I haven't had my coffee yet. 6 decades of cases. So to start with the historical context, ICSID as one of the 5 institutions of the World Bank did not appear out of nowhere. The World Bank was already involved in the settlement of investment disputes in the 1950s and 1960s, with a key precedent being the nationalization of the Suez Canal Company by Egypt, which led to unsuccessful military intervention with UK, France, and Israel, and which was ultimately resolved through the mediation of the then president of the World Bank, Eugene Black. Building on this experience, ICSID was created as a forum for the peaceful resolution of disputes between investors and states. And they're helping to attract foreign direct investment and strengthen regulatory stability. And Latin America has been one of the regions that has had one of the longest and most dynamic relationships with ICSID. From its beginning, when the ICSID convention was presented in the annual report, in the annual meeting in 1964 in Tokyo, 19 countries of Latin America and the Caribbean opposed it. That changed in the 90s with the adoption of the Washington Consensus and the rapid proliferation of bilateral investment treaties led by Argentina and Chile. And I think most of Latin American countries and the Caribbean joined ICSID between 1989 and the 2000s. We have 4 countries in Latin America. The only 4 countries that have ever denounced the ICSID convention are from the region of Venezuela, Honduras recently, Ecuador, and now I'm blanking with the fourth one, Bolivia, sorry, thank you, with Ecuador rejoining in 2021. But I had a slide, I'm sorry. This is the timeline that I wanted to show of this relationship, dynamic relations that I was talking about. If we, a breakdown by country, we see very different patterns or factual patterns. The country that has had the most number of cases, Argentina, 59 cases. But no, let me go back to, in terms of numbers, of share of cases, but this is all missed. I'm sorry. I wanted to show by region, but I don't see it. Yeah, okay. Yes. So Latin America, as of June 30th, 2025, the Latin American region and the Caribbean has had 34% of all ICSID cases, which is a substantive share of cases. That, however, represents a relative decline with respect to prior decades, because we've seen other regions, particularly Eastern Europe and Central Asia, the share of this region growing over time. And now moving to the breakdown by country. So again, very different factual patterns. We have Argentina with cases most related to the economic crisis in 2001. We have Venezuela, 56 cases that are mostly related to expropriation measures. Peru has had a pretty steady number of cases, and Peru stands out as one of the countries that inserts ICSID arbitration clauses in contracts. Mexico had also a wave of cases under NAFTA related to the sweeteners. So again, very different factual patterns that probably reflect the diversity in legal and policy preferences in the region. It is equally important to note that Latin American and Caribbean investors themselves use the ICSID system, so it's not just a one-way mechanism. From the more than 1,058 cases registered now, I think approximately 11% of these cases are involved a Latin American and Caribbean investor. If we only focus on cases where the foreign investor that controls the investment is from Latin American Caribbean, I think it's 66 cases, which represent roughly 6% of the caseload, with Mexico, Barbados, Panama, Colombia, and Chile as the most used jurisdictions. I think it's also important to look at the basis of consent to understand how these disputes arise. Here we have a pie chart comparing all ICSID cases with Latin American and Caribbean, and we see that despite the fact that ICSID was created having contract arbitration in mind, today 59% of our cases consent is in a bilateral investment treaty, followed by 22% of other treaties, then 14% contracts, and 5% investment laws. And what we see is a shift towards more regional and sector-specific agreements. We also see a shift from the predominance of bilateral investment treaties to a higher number of cases based on investment chapters in free trade agreements. And now moving on to outcomes. So the first thing that I want to highlight is that our record shows that there's been a pretty consistent balance in terms of outcomes between investors and states, so that contrary to some critics, not always one party wins. And the numbers speak for themselves. So first of all, as you can see here, around 34% of cases end up with, before a tribunal decides the case with an award, by settlement or by other means. In Latin America, that's slightly lower, it's 32%. And then out of that 68% of cases that end up with a decision by a tribunal, we have that in Latin America, 21% of cases tribunals dismiss on the basis of jurisdiction. Then we have 22% of cases dismissing the claims on the merits, with 1% of cases rejected for lack of manifest legal merit. And then the remaining 56% of cases, the tribunal upholds the claim in full or in part. But that doesn't mean that the investor gets all the damages that it's seeking. Usually claimants get between 10 to 35% of the damages sought. And in only 5% of our cases, the awards, damages awards exceed $500 million. Usually, I think it's 50% is less than 100. But you have here the ratio also between of damages awarded versus damages sought is I think is the majority of the cases is below 50%, and with many cases below 10%. In the interest of time, I'm going to just a few words about the geographic distribution of appointments, which I think is very important. Out of the total number of appointments historically, which I think is like 3,700, I think almost 20% involved nationals from the LAC region. And I think that is actually 136 different individuals, which speaks to the growth in the expertise of the region and its role in shaping the institution. But I think I just want to conclude with a couple of remarks more to the central question. So states have a broad toolbox of a policy toolbox to attract foreign direct investment, and ISDS is only one. I think investment decisions depend on a wide variety of factors, economical, political, and therefore it is extremely difficult to measure in numbers the impact of the availability of ISDS and of treaty protections in attracting foreign direct investment. However, we do see that investor surveys consistently show that the perception of political risk is one of the main constraints in deciding whether to invest or not. And there's also evidence that political risk insurers and lenders for investment projects factor in the existence of treaty protection and ISDS in their risks assessments. With regards to Latin America and the Caribbean, from the data that I've shown, it's clear that is one of the regions that has been most involved in ISDS and that has been most influential in shaping it in its evolution. And this engagement is evolving as it should. And ICSID mission, as part of the World Bank, is to continue to support its member states by providing a neutral and rule-based forum as these policy choices develop. And I'll leave it here.
Well, thank you, Sara. Yeah, and I'd like Manuel to comment to the point, to the last point you were raising, which is you talked about political instability and that being a driver towards the benefit of investment in state protection. And one question always comes up is, and it's funny because myself, when I'm in the US, I'm regarded as a Latin American lawyer, and when I'm in Latin America, I'm regarded as an American lawyer, North American lawyer. So I'm not sure I have a home or a destiny in that regard. But I think that what's interesting is to address then more fundamentally that yes, political instability creates a desire and a need to have something like these protections, investor state protections, but is it all the same in all of Latin America, or is it, or are there differences that we need to be aware of?
No, it's not. Thank you, Dan, and thank you, Sara. It's not, and actually, we have to take a step back now that I have given you a short answer, and comment briefly that the Latin America and Caribbean label that we've recently, in the recent decades, mostly because of development agencies, have attached the Caribbean as an appendix to Latin America, which sometimes does a disservice to the Caribbean because, we tend to cluster it, and it's a very, very complex sub-region in the Western Hemisphere. The same happens to Latin America. Obviously, it's a convenient label, but when we look at countries, not only in their political, social, economic, and legal infrastructure, there are very different realities. It's really a patchwork that is far from homogeneous or coherent. So it's neither homogeneous nor coherent. Political climate obviously is a factor. Political climate is a factor in the US, in Europe, in Asia, everywhere. But in terms of investor-state regimes, it's one of the factors, but not the only one. But on that note, I think one useful way to classify or to at least look at Latin American jurisdictions vis-a-vis the investor-state dispute system is to look at these political, what I call the political alignment clusters. I tend to think about this in three subgroups. And this is just for the sake of simplifying the explanation. The resistors, Venezuela, that withdrew in 2012 from ICSID, that has 60 plus cases against it, almost 50 with ICSID, the rest scattered throughout other regimes. Bolivia, which withdrew in 2007, Ecuador, which withdrew in 2009 but rejoined in 2021. Honduras is the last example. Honduras is in a different category. Everybody's reading the headlines about Honduras for a totally different reason today. But Honduras is a really interesting example because it departed from ICSID in 2024. And we'll talk about that later on what's the political implication of this and what does it do to investor-state dispute systems. So that's the resistors. The second group, and this is again my way of seeing this in an easy way, is what I call the reformers. You could put there probably Colombia. There is an interesting FTC decision in January 2025 regarding the US and Colombia. Colombia has embarked in successive or in reform efforts to adapt to these changing realities. The political factor is looming the same way how it's looming all over the region. It's unpredictable. I don't think it's useful. It's useful for us international arbitration practitioners to be aware of the political reality, but the political reality is entirely outside of our control. So it would be irresponsible for us to do political forecasts. That's what political analysts are for and risk analysts are for. They're useful tools, but to us, that's a that's a no-starter. I think in terms of our skill set, we look at policy decisions, regulations, and obviously advise clients accordingly. Mexico would be the second country that I would put in that category of reformers. There have been interesting developments on the US-Mexico-Canada agreement, basically in a trend limiting the application of ISDS to about 5 sectors. And then the last cluster, and this doesn't do justice to the rest of the region that is in a kind of in a limbo, in some sort of a purgatorium of these international disputes, is what I call the pragmatists. And the name that comes to the top of the list, in my view, is Chile. President Boric, and Chile is in the amidst, second round of election, same polarization that we see in other parts of the world, and the region, obviously. So Boric, during the campaign, said, I'm going to veto the CPTPP, but then as president, it was different. Chile passed it, became a partner, and then also promoted or proposed, China should be here too. So you see the shifting political realities also have some very important implications to the investor-state dispute landscape. Some people may say, well, Uruguay should also be labeled as a pragmatist. So those are kind of groups that I see then in terms of this cluster regarding political alignments.
Yeah, and it sounds to me from what you're saying is that political instability, is not a bad thing. It's when it's too extreme that you're going to have, and before we prepared for this presentation, I called a number of our clients and asked them, how do you see these issues from the investor side, from the countries you're still willing to invest? And we're going to talk about sectors in a minute, but talking to clients in the energy sector, for example, some instability is not bad for business. It's when it's extreme, and when you have extreme situations, now you may not have the investors in the first place, which then means you don't really need ICSID or anything else in the back end because you're just not going to have the investments. And so some of the countries that you mentioned, and we're going to talk a little bit more as we get into the geopolitical issues between the US and China and the war that's being fought throughout that. But I think the message there is then, yes, it's okay to have some political instability because the economic realities may still be there. Is that fair?
May I react to that?
Sure.
Well, I wouldn't frame it that way. Although, it reminded me of a conversation with a Vulture Fund representative years ago when he said, we would not exist if none of these Venezuela cases or these almost impossible cases to recover would exist, because that's the mere reason for us to exist is to earn a buck or two or more in this climate. So I don't think, I wouldn't frame it that political instability is a good thing. I don't think it's a good thing. I think you can maneuver, or you can navigate political instability. So the way I would frame it is like political instability occurs, there's nothing you can do about it, and you can navigate. What you could usefully, I think, the way I would frame it is lawyers or the legal profession, and there's also, nobody talks about the lawyers. And the lawyers, as a group that handles this, are a very important unit of analysis in this formula. Lawyers like to talk about the system, but never talk about how the legal profession has changed and evolved in light of this. States like Argentina created a strategy to defend itself by not hiring large law firms, and that has been replicated in different ways. Anyway, so just to quickly finish here, I think political instability has allowed actors to adapt. And that would probably be, in my view, a better way of looking at political instability, not as a desirable thing, but okay, we can, in light of political instability, we can navigate and perhaps develop or deploy the best strategy possible, sometimes not to win. I remember looking at cases where claimant knew they were not going to win this case, but they wanted a change in policy. And they thought from the get-go, very internally, very intimately with their client, we're not going to win this case. But you know what we're going to do? We're going to set the policy, and we're going to put the state in a position that you can then negotiate other things that you want. This case is peanuts. We're going to let it go, but we're going to put a fight in public. That's clever. That's political. That's maneuvering in an unstable political climate. And I think that's a great skill set of the 21st century lawyer, arbitrators, lawyers, experts, and so on and so forth, in light of this current environment.
And I think it's consistent with something Sara said earlier in terms of that ICSID is coexisting with some of these other elements that are out there as well, whether they're other government elements, other legislative elements. As you said, it could be a tool even if you're not going to prevail. Let's move a little bit now further into Latin America. We've talked about it regionally. Let's talk about it in terms of sectors and the why. Why certain sectors? So when we look at ISDS claims, we see energy, mining, infrastructure, emerging areas like tech, renewables. Our 3 award winners this year, writers, if you notice, that's what they were writing about. So the young people certainly are seeing it, maybe faster than us old-timers. But why is that? And I think I wanted to start with Sara on this, and then I'll come back to you, man.
So looking at our historical record, we see that this is the pie chart distribution, also comparing worldwide with Latin America, and indeed oil, gas, and mining takes the bigger share with 28% of our cases, followed by transportation, 14%, which is slightly higher than worldwide, and followed by electric power and other energy cases, 13%. The other sectors, which are information, communication, finance, construction, etc., are between 6 to 10%. But we see a wide variety of sectors involved, which reflects also the economic diversity of the region. So, but this is looking into what has happened so far. So a look in the past. If we have to look beyond, this might shift, obviously, and it is very difficult to make any predictions. However, I think one important shift that is worth highlighting is that we've mentioned by some of the winners of these papers is the energy transition that is transforming markets, technology, and legal framework at an unprecedented speed. To give you an idea of the magnitude and the speed, I think that from data from the International Energy Agency, in 2024, 92% of all new power generation capacity was in renewables. I think 2025 is set to have a capital flow towards energy of 3.3 billion, and out of these 3.3, 2.2 is also for renewables and nuclear, and also like lower emission energy sources. And I think that the prediction is that global demand of oil will peak in 2030. So this can very well shift what types of disputes might come in the future. And if we look at how this transformation has already impacted our cases, I should mention the growing number of renewable energy cases brought by green investors. We have here the cases against Spain, but also against other European countries. Out of this 77 cases that we've had in total, only 11 involve Latin American, Caribbean countries, so a relatively a small number so far. We could also mention what hasn't happened yet, despite fears of a wave of cases directly related to the phasing out of coal. For example, we've only had so far a handful of cases. This could obviously also change. We've had 2 cases against the Netherlands that were, none of them Latin America and Caribbean region, 2 against the Netherlands that were discontinued, 2 against Canada that ended with an award declining jurisdiction, and 1 case that is still pending. And maybe another thing to mention is the development of carbon markets. Now under the umbrella of Article 6 of the Paris Agreement, we've only had 1 case so far that is connected to carbon markets more clearly, which is the Koch Industry versus Canada case related to the cap and trade market in Ontario. That is obviously just one example, but it's an illustration of how these carbon market-related disputes can come up in in ICSID cases. And finally, also, I wanted to mention the important developments happening in the international legal framework, and I'm talking not only about new treaties, but also the impact that the advisory opinions of ITLAWS, the Inter-American Court of Human Rights, and the ICJ may have in ISDS. So these are another variable. For example, the recent advisory opinion of the ICJ said that states' actions with regarding to fossil fuels, whether it be in the production or consumption, such as granting exploratory licenses or subsidies, may constitute an international wrongful act attributable to the state under customary international law. And And also very importantly, it said that states' failure to regulate private investors to limit the emissions can also constitute an international wrongful act. So this suggests that ICSID tribunals may need to assess whether the state's actions or omissions are in compliance with their climate change obligations.
Yeah, and so I mean, if you sum it up and you sum up the charts that you were using, Sarah, I mean, I think what we're seeing is that over 50% of your ICSID cases are in the energy, oil and gas sector, something related to that, and the evolving markets, the environments of that. Manuel, why don't you comment, if you can, on some of the other political changes, and that what if you have a crystal ball and you're telling your students what to look out for in the next 5 years, what do you see in terms of Latin America?
The first thing I would tell my students is that don't believe in crystal balls. Let me preface that with a comment that I think belonged. It was kind of a bridge between the first question and this one, and I had it in my notes, so I'm going to use it because I think it's relevant, and then I'll touch on the political, which is part of the Latin America and Caribbean landscape vis-a-vis ISDS shows a reality in transition, and the political aspect is important. And that transition is marked by this broad debate, political debate actually, against traditional globalization, the word of the late 90s and the 2000s, globalization, what led actually the World Bank to think in terms of let's stop building bridges and let's start building institutions. In the 1990s, and you saw Sarah's first slide that showed all the accession to the ICSID Convention. You see that the big upsurge is in the 1990s. That's when the World Bank stops financing infrastructure programs. Guess what? Because of what permeates everything that we're not going to talk about today, but I think it's a great, well, it's not great at all, it's corruption, but it's a constant element that permeates almost everything, sprinkles everything. It sprinkles political debate, sprinkles ISDS. Now tribunals are wondering, still figuring out, what do we do with this? Allegations of corruption, what about corruptions in the proceedings, and so on and so forth. So the decision to shift from let's build bridges and build institutions is what incentivized states, many Latin American states also, because there was the carrot was you will get financing for your other stuff if you become a player and you adopt this global rule of law catalog, which includes you have to accede to the ICSID Convention. And you see that first wave of states, and then in the 2000s you see that. So that I think it's an important element for this political.
Well, and let me stop and comment on that, which I think it's worth saying the flip side of that same corruption issue, which is also driving why I believe it's a factor both in the investment treaty world as well as bleeding over into the commercial arbitration world, where you do not see a high level of settlement of these cases, that they do go to final decisions because of the fear of corruption and the fear of states, even when they're doing the right thing, that someone is going to accuse them of corruption if they settle privately a dispute that otherwise will go to a final award, a final decision. That's why I think you see such bad statistics in international arbitration generally in Latin America in terms of settlement of those cases.
Right, that's absolutely true. That's a great observation then. And nobody talks about that. Reason for taking you all the way till the finish line is because, we want this to be, well, that's not the only reason, but one of the factors is let's not take any risks, go transparent all the way. We'll be in an adversarial mode to the end, and we'll avoid we don't want to sprinkle this. So, but what I wanted to say is that there has been a shift. This transition, this Latin American Caribbean transition, shows a shift towards ESG and regulatory flexibility. So Latin American governments, it's across the board, depends on what version and flavor of populism you see in politicians running for office, have increasingly promised. Some have, when they win elections, have been champions of adopting laws and regulations to protect the environment, combat climate change. We heard some of that from our fantastic winners this year, which can sometimes lead to disputes with investors under older treaties. So we see also an interesting surprise element among political actors that because of their actions, the policy actions, have triggered then old treaties, old regimes that everybody had forgotten about it. So that's something that happens that I think affects then the political stance that states have towards ISDS. So it's not just the left and the right, the socialist versus the capitalist, or the pink movement, which is how these sort of leftist governments that are really pro-market have been labeled. It's more nuanced than that. I think we see a lot of pragmatic decisions even among states that are supposed to be just led by a populist autocrat and no pragmatic at all. And the world tends to forget that the reason why someone stays in power for so long is especially because they're pragmatic. So not because they can speak one way but act the other way.
And that actually brings us back to the audience and the next question, if I can get the clicker, we'll bring back the question. Because I think, Manuel, the way you set that up is perfect for the question we want to ask now. And this is a multiple choice question. So I will need to show a show of hands on the A, B, or C, but the question is, do you believe that political shifts towards socialism raise the likelihood of more investment claims? Manuel tells you that, well, it's not so simple, but show of hands for yes. Okay, that's a pretty big number. Show of hands for no, C. Okay, just one or two. And then how many of you just don't care in the middle?
There you go. You have a lot of no.
So, but okay, but look, I've often have said throughout my career as an international arbitration lawyer in Latin America, I've always felt like I'm a parade sweeper. My corporate partners are always in certain jurisdictions several years before I'm there, and they're doing the corporate deals, they're doing the investments that are happening, getting done, and it's years later that we all of a sudden see the investment treaty disputes, we see the commercial disputes, so it's really hard to predict for the three of us that are sitting here because we're waiting to see where that's coming. But nonetheless, and I know that Professor doesn't like to tell the students about the crystal ball, but we are going to play the crystal ball game. We're going to continue to do that. And the question, and I'll start with you, Professor, this time, is are the recent political shifts in countries like Mexico and Colombia, and you mentioned, and you put them into your nice little different groupings, but is that increasing the risk, at least into the future, of additional ISDS cases?
Well, thank you, Dan. So recent political changes anywhere, but the two specific jurisdictions that you mentioned, Mexico and Colombia, have obviously led to increased government scrutiny, pushback against the ISDS system. Anybody who reads the news may know that. May also know that it's driven by concerns over national sovereignty. That's a common concept, not unfounded, by the way. The resistance, the historical resistance that Latin American states had towards this or any other system that would take not in a symbolic way, but in a real way, their sovereignty. That many states had been still figuring out, what do we do with all these resources that we inherited, and but our first reaction, and it's a very human instinct. It's not just an elaborate decision. Obviously, when you're governing a country, the human instinct is, why am I going to give this resource? Why am I going to give the decision to you? If I don't have the capacity to understand this system, why am I going to be the proponent of ISDS when that's not my system? so we see some of that. High cost of claims, obviously. If there is if the exposure of the risk is high, I mean, in pre-dispute, not the Venezuela case, when nobody knew or figured or even imagined how much this was going to cost and what the impact of it was going to have. Crippling basically almost everything. Doesn't matter if you have the largest reserves, but you're crippled. And the desire for policy space for domestic reforms, remember, going back to political speech, it's all about your people. You have to deliver to your people. So the reforms, the domestic reforms are the first and foremost. So interestingly, we are from the U.S. looking at all these jurisdictions, but it's very different being there. Your local council can tell you that. It looks very different from there because what drives the policy is the people who live in the territory. It's not the foreign investor is a factor, but it's not the main reason why policy is approved or endorsed. So particularly in the energy and environment sectors, just very quickly examples. Mexico under AMLO, López Obrador, and now Sheinbaum, we've seen the seizure of a railway, the electricity law, legal reform allowing renegotiation of about 28 contracts, and that triggered arbitration, the Balkan case involving allegations of illegal expropriation of a U.S. company, BITs. That would be a whole day for a conference. I think out of 32 BITs, 29 provide for ICSID arbitration, plus 14 multilateral treaties. Then Colombia under Petro, there are a number of different controversies. I just mentioned earlier the FTC decision, which is, offered a binding interpretation, narrowing the scope regarding the U.S. and Colombia. The Constitutional Court of Colombia has also weighed in. There are also some ICSID cases registered involving Colombia after 2015. So there are specific developments that obviously are shaped by the political regime, and also, and I'll conclude with this, by the perception, the external perception of what that political regime might do. And that alludes to your crystal ball. Because it's not just what the political actors are doing in their own territory, but also the prediction that the outsiders have, or at least try to pin down on what they might do. And that's highly speculative. Sometimes we're lucky, and then whoever said, okay, they were going to do this, and they do it, then becomes like the guru of the world. So anyway.
Sara, anything you can comment on this? I know, again, it's a crystal balling to the future, but.
Yeah, well, the first thing I want to note is that as counsel at ICSID, I'm not going to comment on any specific country or shifts. But what I can do is say what our historical record can and cannot tell us in terms of predicting new cases. And I agree with Manuel that not big political shifts not necessarily mean more cases, because our cases are very highly fact-specific, and trends tend to be driven more on the basis of the type of measure and sometimes even more importantly, how it's implemented. The degree of transparency, the degree of stakeholder participation sometimes is a lot more important. And therefore, we should be extremely cautious in translating the conclusions of one specific set of circumstances to another. Second point is that, as you mentioned, sometimes cases surface 10 to 15 years after the political measure is implemented, so it's very difficult to predict the full impact. Third, that political instability has not always been a good indicator of cases. We've had states that are very politically stable that have faced high substantive number of cases. For example, Spain with the renewables, while other states that are less stable have faced fewer cases. So again, from our record, some patterns can be, can give us some insights, but it is very difficult to reliably make any predictions. So what they do tell is the value of predictability, of transparency, and of well-communicated legal frameworks in effectively managing investment risk.
Yeah, and to your point, and I think it was showcased in one of your earlier slides, when you actually look in 2025, most claims that were filed in ICSID in LATAM were in Central America and the Caribbean. You're not seeing these cases in Colombia or in other locations as such. Now, like you said, whether that's coming 5, 10 years later, it's going to be very hard to tell and very hard to predict. And again, I go back to the same notion, at least what I hear from clients is instability doesn't necessarily mean I'm not going to invest. And if I am going to invest, then I do need a structure to have some protection for that. So those things kind of seem to go hand in hand in regards to that. So, but now let's sort of shift away a little bit from LATAM itself, but shift now more to ISDS as an institution, so to speak, as a process. And what we know is that in Europe there is animosity, the growing on ISDS, and the question becomes, is that going to be contagious to Latin America? Are we going to see some of those same trends into Latin America? And Sara, I'll start with you again on that.
So I think, as we've mentioned before, there's no unique model for Latin America. In the Caribbean, as we were mentioning, the Latin American states have engaged in the recalibration of their investment policies in very diverse ways, and we've seen some Latin American countries updating and modernizing their treaties, sometimes by clarifying key substantive provisions like FET, sometimes by imposing greater transparency requirements or by addressing the regulatory space. But we've seen other countries like Brazil that have prioritized institutional mechanisms to foster dialogue and dispute prevention rather than international arbitration. We've had states like Peru who have used ICSID arbitration clauses in contracts as a way to have greater control or limit what type of disputes can have access to ICSID. And we've seen states that have limited or withdrawn from their previous treaty commitments or even the ICSID convention. So big variety. But if we move past the individual strategies by country, we do see Latin America very involved and engaged in global reform initiatives, such as the World, UNCITRAL's Working Group number 3, where the states are exploring procedural innovations, a stand-in mechanism, and standards of conduct, etc. ICSID here has been participating actively in these meetings by providing what ICSID with UNCITRAL helped prepare the code of conduct for arbitrators. We've provided in these meetings insights from our case data and also about our experience in the implementation of our new 2022 rules, which incorporate many procedural innovations. And as some of you may know, it took us 6 years for this reform process for the new rules, with several rounds of consultation to the member states and other stakeholders. Another initiative where Latin American countries have been very involved is the one led by the OECD about the future of investment treaties, which is all about reforming treaties to align them to the objectives of the Paris Agreement. Here, exploring how to foster green investment, how to safeguard a regulatory space to adopt ambitious climate policies, but at the same time protecting investors. So again, the main idea is reform, which is not we're very short on time? Okay. So again, the idea is reform, which is not necessarily equivalent to rejection. On the contrary, I think it's just a very healthy way of a legal system maturing and adapting to new economic and political realities.
So we're almost out of time, but I would be really amiss if I didn't touch on, if we had a panel, we didn't touch on U.S. politics and sort of how that's being fought, the war, as you can see from our little diagram with China and the U.S. And I'll start with you, Professor, first on this one, which is how do we look at this again and say, how's this going to play out, this tug of war, both in terms of the countries directly involved in this tug of war, Argentina, Venezuela, Colombia, but then also what does that translate into in terms of the investment world and ICSID ultimately?
Thank you, Dan. So, interestingly, you say, okay, let's move away from Latin America, but I think the U.S.-China rivalry in this context is in great part because of Latin America. So that rivalry is driving a rivalry. I'm having a bad English day today, by the way. That's my Sunday for you in Miami. So it's right. If I say it correctly, most people in Miami would not understand me. So sorry that I need to translate for the proper English speakers. The Spanglish. No, it's in Miami. And so anyway, the China-U.S. rivalry drives a broader change in foreign investment and its protection in Latin America. It's not just a simple shift in the source of capital, which is how most of the coverage and most of the commentators, actually you read a lot of the comments on ISDS and China, and it's mostly, and Latin America, it's mostly about all this Chinese capital that's coming. The Belt and Road Initiative brings X number of billions of dollars. It's not just capital, it's other things. There are obviously shifts in investment patterns. China has become a top trading partner for much of Latin America and a major source of foreign direct investment, loans, infrastructure projects, all, most of them under the famous Belt and Road Initiative. The U.S. has responded to this influence with increased engagement and a strategic focus on the Western Hemisphere to counter China's growing presence. Nowadays, we see it in a very polarized way, not in one of the leading to one of the situations where we would really like to have a crystal ball because it's not very clear what the strategy is. And there are all these divergent regional approaches that have created also a split in the region with countries like Mexico trying, because it has to move closer to the U.S., and Brazil moving away from it, leading to these diverse investment strategies that have everyone puzzled. And it was kind of an unexpected move, and also how some actions by the U.S., political decisions have, backfired because have created incentives to China and to other countries to partner and strengthen with China. So there are some geopolitical considerations. There are some strategic investment aspects, focus on non-traditional security, and so on and so forth.
Well, and I'm going to turn the last word to Sara on this, because I think throw into that geopolitical tug of war and fight of King Kong and Godzilla, you also have the fact that countries like Brazil and Argentina are trying to come up with their own investment treaty processes, whether it's the CIFIA in Brazil or whether it's RIGI in Argentina. They are trying to also implement competing other forms of regimes to deal with investments, to attract investments, but not be subject to. So with all that, and to sort of conclude, where do you think this is going to take you in terms of ICSID cases? Now, and I'll load the question as a leading question, given that I am a litigator after all, and to say, it would seem to me that ICSID is still in good state when you look at the number of cases that are still coming and still happening. So even with all these competing factors and so forth, what is the health of ICSID going forward as you see it?
The numbers, as you said, are actually, very good. In the last few years, we've had record number of cases, but we cannot know. What I would say is that ICSID is compatible and coexists with many other alternative dispute resolution mechanisms, and it should. Even ICSID offers conciliation, mediation, rules, and fact-finding. We have new mediation rules now in 2022. So again, I don't have a crystal ball, but so far our numbers are strong, and I think it is a system that coexists and can be complementary to others.
So I'll let the audience be then the last crystal ball, and so we'll ask you the last question for this panel, which is, in which direction should we trust for international remedies in Latin America? Should we continue down the path of strengthening and reforming ISDS, or should we look for another alternative? So show of hands in terms of A. All right, well, it looks like you're in good shape. Thank you very much, everybody, and thank you to our panel.
How did Man versus ICSID do?
You did it. You did well.
Make it like Ed Mullins.
Yeah, exactly.